Thank you for having me. Um, I think it is important that Kenya establishes a specialized division for handling international crimes, and this is why. Because generally the criminal docket is really clogged with all types of cases. The High Court handles homicide cases, defilement cases, robberies, all types of cases actually. And so that division, criminal division, is generally what I would say contaminated with all types of cases. Now, uh, generally the cases take very long because of the shortage of judges. So what has happened in the judiciary, the Chief Justice has established specialized divisions. We have family division, we have anti-corruption division, and land and environment division, all sorts of divisions. So the judiciary realized that when specialized judges handle specialized cases, the cases move daily because the judge is focused on a daily basis on what they are doing. So then jurisprudence develops and it crystallizes. It becomes even easier from the magistracy all the way to the Supreme Court. So we began with establishing counterterrorism courts, and now we have transnational organized crimes courts. No, those are serious cases. Those are cases that actually, I would say, violate the sovereignty of the country, including now international crimes, which not only just violate sovereignty of a particular country, but has a greater impact across the borders of a country. So I think, in my view, establishing a specialized division for international crimes would enable judges to quickly learn the law, because this is not a law that we have practiced since we left university. It is a new emerging area for us in Kenya. Only have one case so far that we've handled. So a specialized division will enable proper case management, number one. Jurisprudence will grow faster, number two. Capacity building for the prosecutors, the magistrates, and just that a common understanding of what we need to do as criminal justice actors in the division. First and foremost, Kenya belongs to a community of civilized nations. International crimes like war crimes, crimes of aggression, genocide, and other crimes, all those crimes are prohibited under international customary law. And therefore, automatically, Kenya being one of the countries that belongs to the community of civilized nations should be able to just handle those crimes. But anyhow, Kenya has domesticated the Rome Statute. That was way back in 2005. And in 2008, Kenya legislated the International Crimes Act, which now grants the High Court the jurisdiction and capacity. That is the basis upon which Kenya can handle international crimes. Secondly, Article 2.6 of the Constitution states that all treaties and agreements ratified by Kenya form part of the laws of Kenya. So that actually is the basis upon which Kenya can handle international crimes. The Victim Participation Act is anchored in Article 50, Subarticle 9 of the Constitution. It became necessary to have this law embedded in the Constitution because victims had been neglected over the years. Their voice was not being heard. Victims only appeared in court as witnesses. They had no idea of what was happening. And even when victims had an advocate to represent them, the advocate simply introduced himself and just told the court that he is watching brief. And that was it. He had no right to ask any questions, no right to say anything during bail application, no participation to the sentence rather, so that the victim's impact is heard by the court. So that was the basis of having this legislation embedded in the Constitution to ensure that the rights of the victims are protected under the Constitution. And pursuant to that, the Victim Protection Act was enacted in 2014. Now, under the Act, the victim is not a mere robot that sits in court just following the proceedings. A victim participates in the proceedings actively. A victim has a voice before the offender or the perpetrator is released on bail. If the victim feels threatened, then the court must consider the views of the victim. And the consideration comes through probation inquiry. The court directs the probation officer to interview the victim so that the views of the victim are taken into consideration during bail hearing. And now during the hearing itself, the victim and the advocate sit in court and participate. The law does allow now, the Victim Protection Act allows the victim to ask questions, but the court sets parameters. We already have jurisprudence up to the Supreme Court, the Lendrix Waswa case. The Supreme Court states that the court has to set parameters within which the victim can participate. So it's up to the trial court to look at the facts of the case and the circumstances of each and every case and lay down the basis for the victim's participation. But the advocate for the victim must notify the court that he will be asking questions. And for us now, there are two cases already by the High Court that victims' counsel can cross-examine a witness for the prosecution. I would say that for me personally, I started hearing of international criminal law after the post-election violence of 2007, 2008, when the president and the deputy president, our current president now, were arraigned at The Hague. It became a big debate, and there were issues of crimes against humanity having been committed in certain parts of the country. And so a commission of inquiry was established, and that is when I started actively following about international criminal law. And finally, the two, as I've indicated, were arraigned at The Hague. Now, but at the same time, in the year 2008, Parliament quickly came up with the International Crimes Act, and it was passed without any arguments from the legislators, and that became the law that domesticated the Rome Statute. Now, as it came 2010, there was a lot of piracy in the Indian Ocean. And I would think that because piracy is also sort of an international crime, a court was established in Mombasa, and the pirates were arrested in the high seas, not just within the Kenyan territorial waters. Their cases were heard and they were jailed in Kenya. Then after serving prison, they were repatriated back to their country. So you can see the participation of Kenya in handling international crimes. So then in 2017, again, there were pockets of post-election violence leading to 12 police officers being charged with crimes against humanity, like murder, rape, and the case also involved the killing of baby Pendo, a minor who was clobbered to death. So the case is pending in court, and recently we have a decision by a judge of the High Court that indeed Kenya has jurisdiction to entertain, to handle crimes, international crimes.